Namaskar, this is Akhilesh Bhargava again. Welcome to Tidbits on Business and Finance with me. The Supreme Court in its recent order passed on 20th February 2019 in the case of RCom and Ericsson held RCom and its two companies to be guilty of the crime of contempt of court. The Supreme Court held them guilty of contempt of court for having filed misleading affidavits and undertakings before the Supreme Court in the matter of payment of dues by RCom to Ericsson. The court held that in case RCom fails to pay these dues to Ericsson within 4 weeks of the order, then the chairman of these companies, one of which is Mr. Anil Ambani himself, will have to go to jail for a period of 3 months on charges of contempt of court. The Supreme Court also levied a penalty, a fine of rupees 1 crore per company, and said that if it is not paid within 1 month, within 4 weeks, then these particular chairmen of these companies, who are 3 of them, including Mr. Anil Ambani, will have to be in jail for an additional period of 1 month. This case is not just one of recovery by one company from another, but it has got far more larger issues involved. This is a case of a cash-strapped, a debt-trapped billionaire who had to deliberately dodge the law, who deliberately misled the court because of the failure of his bankrupt companies to honor the unconditional payment commitments that they had made before the Supreme Court. This case is also one of Mukesh Ambani refusing to bail out his brother Anil Ambani. And the most disturbing aspect of this case is that in case Reliance Communications, RCom and its group is not able to sell this telecom spectrum and related assets to RGO or to any other buyer, then the banks are going to be left high and dry. The banks are going to face huge losses because they have an exposure of over 35,000 crores to RCom and its group of companies. This case also indicates that Anil Ambani and his companies have got very few or limited options to raise money, such that he had to appear in the Supreme Court on charges of contempt of court, and he was actually held guilty of contempt of court. This entire case relates to an unconditional affidavit or undertaking which was given by RCom and its 2 other companies before the Supreme Court, agreeing to pay the dues of Ericsson by 30th September 2018. The facts of the case as narrated by the Supreme Court are that Ericsson and RCom entered into a services agreement in January 2013, under which Ericsson agreed to operate, maintain and manage the entire telecom network of RCom for a fee. RCom soon started defaulting on its payments to Ericsson, and Ericsson in 2017 dragged RCom and its other 2 companies to the NCLT for a winding up petition. The NCLT immediately admitted this particular insolvency petition filed by Ericsson and appointed insolvency professionals to start insolvency proceedings. RCom immediately went to the NCLT and said that it has settled its dues to Ericsson, and as against dues of 1500 crores, it has agreed to pay by way of a final settlement 550 crores to Ericsson by 30th September 2018. RCom also went to the Supreme Court seeking quashing of the winding up proceedings that were filed by Ericsson, and rather gave an unconditional undertaking to the Supreme Court that the dues will be paid to Ericsson by 30th September 2018, and this is where the crux of the problem lies. RCom did not pay its dues by 30th September 2018. It sought more time. And it sought more time on the ground that it had not been able to pay these dues since it was not able to sell any of its assets. In other words, RCom started linking the repayment of dues to Ericsson to sale of assets, which it was never so. This was a misleading statement it made to the courts. Ericsson immediately filed a contempt of court petition before the Supreme Court. The Supreme Court still gave another 60 days to RCom to repay the dues to Ericsson. It said it must pay the dues by 15th December 2018. Reliance again defaulted and sought more time. And that was the point of time when the Supreme Court refused to give any more time and the contempt of court proceedings gained traction. By 21st of January 2019, RCom had paid 118 crores against the total dues of 550 crores plus 12% of interest, and it promised Ericsson that it will pay the balance dues by 31st January 2019. The fact is that it failed to make any such payment. Interestingly, on 1st February 2019, RCom informed the stock exchanges that it is no longer going to resist the winding up petition filed by Ericsson, and in other words, winding up will take place. All this of giving false affidavits, linking the payment to sale of assets, informing the stock exchanges that it is now no longer going to resist the winding up was only meant to mislead the courts deliberately. Ericsson, of course, contested the case, and finally the Supreme Court held that RCom had no intention to honor the unconditional commitments it had made for the payment of dues to Ericsson. At this point of time, Reliance said that it has not been able to pay its dues because of the refusal of the Department of Telecommunications, the DOT, to permit the sale of its spectrum to Reliance Jio. The Supreme Court was very considerate. It actually, in parallel proceedings, called the DOT, summoned the DOT and asked them why were they not giving the NOC to RCom to sell the spectrum and other assets to Reliance Jio for a sum of 18,100 crores. And that is where another attempt of RCom to mislead the Supreme Court surfaced. The DOT said they had no problem in giving the NOC for the sale, but under the guidelines, Reliance Jio was required to give an undertaking that it will be responsible for all the liabilities of RCom upon purchase of the spectrum, and it was the failure, the refusal of Reliance Jio to give such an undertaking to DOT which was holding back the sale of the spectrum and other assets by RCom to Reliance Jio for a sum of 18,100 crores. So the inability of RCom to sell its assets to Reliance Jio was not because the DOT was not giving an NOC, but it is because RJio was not willing to take over the entire liabilities of RCom, and this is the reason the assets were not selling. The Supreme Court saw it through. It was seen that RCom had been misleading the court by way of misleading affidavits, false affidavits. It had no intention to honor its payment commitments, and even its ground saying that it has not been able to sell assets because of the refusal of DOT to give NOC was false. The court said that the directors or the chairmen of the three companies who gave these particular affidavits are guilty of contempt of court, just as the companies are. It said that the balance sum must be paid by RCom to Ericsson within a period of 4 weeks of the order, failing which Mr. Anil Ambani and his two colleagues would go to jail for a period of 3 months. It also levied a fine of 1 crore per company, as we said, and for failure to pay that within 4 weeks, again there was an imprisonment for a period of 1 month. It all shows the entire episode to be one of taking the judiciary for granted. It seems strange and it seems alarming that these kind of misleading affidavits and undertakings can be filed even before the Supreme Court, notwithstanding the fact that contempt of court proceedings would be imminent. So, while on the surface it looks that this is a case of recovery between Ericsson and RCom, but to us there are far more larger issues involved. And the first issue is the financial capacity, credibility and position of Anil Ambani and group of companies so poor, so restricted, so gone down that they have not been able to even arrange a sum of 550 crores to be paid to Ericsson as was contracted. If that is so, then the entire group of companies of Anil Ambani seem to be in danger of a financial collapse to us. The group just doesn't have the assets or the credibility to raise the sum of 550 crores and it has faced contempt of court proceedings. The second issue is that it is reported that RCom had sold its spectrum, telecom spectrum and other assets to RGO for a sum of 18,100 crores. Despite this sale having taken place, of course, it is contingent on a DOT NOC, but despite this, what is the reason that Mukesh Ambani did not bail out his brother for a sum of 550 crores? The more disturbing aspect is that if RCom is not able to sell its spectrum to RGO or to any other buyer, that means there is going to be a complete collapse of the company. Those 18,100 crores were meant to be repaid to banks, and banks might just get nothing. It is very clear that in the case of RCom, where banks have an exposure of over rupees 35,000 crores, a huge loss is imminent to the bankers. The other issue is that is Anil Ambani so cash-starved, so debt-trapped that he has not been able to raise this 550 crores and has been held guilty of contempt of court? And finally, is it that tycoons or influential persons take the judiciary for granted such that they don't even hesitate in filing misleading affidavits and undertakings deliberately to mislead the court and thwart the process of law? So to us, there are far larger issues involved, and it now has to be watched. How do the Reliance group of companies led by Anil Ambani really fare and come out of this crisis? At the moment, if press reports go by, he's fighting with his back against the wall, and a fire sale of his assets is very imminent and on the cards. This is Akhilesh Bhargava signing off till we meet again. Namaskar.
If you like this video, please share it, and we would love to hear your comments in the comments section down here. Also, please do like our Facebook page and follow us on Twitter to get minute-to-minute news updates. For more such shows and videos, subscribe to our YouTube channel.